唔該晒各位嘅委員，咁我哋
Welcome. We now have a quorum. So let's get started on the meeting of the Bills Committee on the Apology Bill. First, I'd like to invite the administration in.
好咁咧就其實各位委員喺過
Members, in past meetings of the Bills Committee, we discussed policy issues relating to the Apology Bill, including the scope of application, protection on the statement of facts, as well as the decision maker's discretion. The administration also provided written response to questions raised by members, and relevant papers have been shared with members. And we're looking at CB brackets for 1038/1617 brackets 01 and CB brackets for 1085/1617 brackets 02. Can the administration walk us through the papers, please? Dr. An Chang. Meanwhile, the administration also responded to questions made by the legal counsel on the 20th of March, and relevant paper has been circulated with members. CB brackets for 1086/1617 brackets 01. I will also invite the legal advisor and the administration to walk us through this paper. So I'll now hand over to the administration. Chairman, Mr. William Liu will walk us through the papers. Thank you. Since the last meeting, we submitted a few papers to LegCo. The bracket was CB brackets for 1038/1617 brackets 01. And the paper responded to questions raised by Mr. James Toh, and we explained the government's stance. And there was also an annex to the paper to explain the concepts of just and equitable. So that's our first paper. The second paper was CB brackets for 1085/1617 brackets 02, and the paper addressed the comments from the public in the open hearing last time. During the hearing, we took in various comments, and subsequently we came up with this written response. Apparently, the public feels that there are two options. First of all, option 1, absolute protection of statement of apology, and option 2, protection with discretion. We analyzed these options, and we found that for absolute protection, as we said before, the government has concerns on the basic law and the Bill of Rights. The so-called absolute protection can actually bring about uncertainties. If the courts feel that the absolute protection is against basic human rights principles or the basic law, the court might deem the absolute protection invalid. So the apology maker might think that he or she is enjoying absolute protection, but subsequently when the case is taken to the court, the situation might be different. So having considered the Bill of Rights and basic law, a more pragmatic approach would be to offer discretion under exceptional circumstances, under the principle of just and equitable by the decision maker. They can exercise such discretion. This discretion should not be exercised casually, and in most cases, there's no need to exercise discretion. In most cases, ample evidence is available to the court, and we might not have to rely on statements of facts within an apology. That's why we find the second approach more appropriate, and that is allowing discretion for the decision maker. And as for the concept of just and equitable, there were some uncertainties, but according to Annex 1 of the first paper, the concept of just and equitable has been explained in different cases. And in the Hong Kong laws, the phrase just and equitable showed up almost 90 times. So this is not a novel concept to Hong Kong, and we find this wording appropriate. But we realize that different members might have different views on the on what the decision maker has to consider. Under exceptional circumstances, we made amendments, and those proposed amendments were sent to LegCo yesterday, so members can consider them. We took reference to the mediation ordinance and the concepts within about public interest. So we mainly considered public interest and whether it's in the interest of the administration of justice. These two concepts were borrowed from the mediation ordinance. And we included that in Clause 8, brackets 2. So this might offer more guidelines to the decision maker, and we are happy to adopt this such wording. So these were the main papers since the last meeting, and the legal advisor also raised other questions on the clauses. The speaker is not coming through. Please speak to the microphone. On the Clause 8, brackets 2, we submitted a draft to LegCo explaining that we can make amendments if needed. We suggest drawing up guidelines for on Clause 8.2 for reference by the decision maker, and two concepts were raised. They were based on concepts borrowed from the mediation ordinance. First of all, the acceptance of statements of facts and whether they are in public interest or the administration of justice.
Interest of administration of justice。咁呢個就係喺個調解條例裏邊係去有嘅。咁我哋覺得都可以即係
So these have been incorporated in the existing ordinance, so they are of reference value. So members can consider whether their worries could be alleviated through such wording. As for other questions from the legal advisor, the administration offered two papers in response. One was drafted in March and another in May. They were rather technical and complicated in nature. So we might wait for the clause-by-clause examination before explaining further. Thank you very much. Can the legal advisor offer his views? I agree that for the more technical issues, we can wait for the clause-by-clause before elaborating. Earlier, we asked the government about the scope of application of the bill, and they explained that this does not apply to electoral proceedings. In other words, members can still quote apologies made by other persons. As for the definition of the scope of application, and in paragraph A, they talked about these applicable procedures according to Cap 81 and 85 of the electoral ordinance. Sanctions can be imposed on the certain behaviors of members, and the wording here is not very clear. Under clause 6 brackets 1b, it covers other proceedings conducted under an amendment under the IGCO. If the Public Accounts Committee or Select Committee of LegCo, according to the LegCo Powers and Privileges Ordinance, if witnesses are called by LegCo for inquiries, whether will these proceedings constitute the so-called other proceedings, this is unclear. And for LegCo inquiries, for example, the recent Select Committee, the nature is similar to the other inquiries under the ordinance.
Last night, the administration indicated that to avoid unnecessary disputes, they will be moving a CSA and to amend to stipulate in the schedule that the scope of application would not include the proceedings of the Legislative Council. I think members would have received that at CSA already. I think this is the proper approach. Finally, regarding the CSAs, and also regarding, since it's related to the speeches made by electoral members and the execution of duties, whether or not the bill applies to electoral proceedings, that this topic is, the electoral has never been consulted. So the committee therefore may need to consider whether or not, in relation to to this issue and the CSA, whether to decide whether or not we need to consult all electoral members. According to my observation, I think there are two issues that we need to discuss. First of all, the discretion under Section 8, bracket 2. And the administration has now proposed a CSA, which is tabled today. So we can discuss that today. Secondly, our legal advisor, asked whether or not the bill applies to the proceedings of this council. So if members would like to discuss whether or not the bill applies to this council, the administration has now moved a CSA, which is tabled for members. So I'd like to ask colleagues whether, as our legal advisor pointed out, that whether we need to consult all our colleagues in this council. So that's the second question. So, legal advisor, now regarding the first question concerning Section 8, bracket 2, I think earlier on we've spent a lot of time discussing that already, and the administration has already moved a CSA, which we will be looking at. Secondly, now that we have this new issue which we have to discuss, I believe this is a relatively simpler issue. Could we, first of all, listen to members' views regarding the second issue? I'd like to hear members' views regarding this point. I think this is very important. For the administration, regarding the second issue, do you have anything further you'd like to add? Thank you. regarding this proposal, we are rather surprised, and we also have doubts as to whether or not it is really necessary. As to whether we should consult all electrical members as to whether or not the bill applies to electrical proceedings, I think we can go back to the bill itself. We've conducted 2 rounds of consultation in June 2005 and February 2016, and we published a consultation paper and the report of the consultation in November 2016. And during the second round of consultation, a draft of the bill was already circulated to members. We've already studied the practice in 30-odd jurisdictions overseas, and in all these jurisdictions their apologies legislation does not apply to their own legislative bodies. So our bill is aimed at resolving civil proceedings. In electrical, we do not have civil proceedings, and we've never thought that the bill would apply to electrical, and that is why in the bill we did not say that the provisions apply to the Legislative Council. So we therefore believe that the proposals in this bill does not apply to electrical at all, and that has always been our position, and this is consistent with the ordinances in other jurisdictions. Under the circumstances, while we are grateful for the submissions received regarding certain areas of the bill which are not very clear, including the legal advisor's question whether or not the bill applies to the proceedings of this council, in order to allay members' concern, we submitted a CSA. Hopefully we can eliminate all the doubts. Now, first of all, our present proposal, the proposals in the bill, will not affect the operations of the Legislative Council. The second point we'd like to reiterate is that the CSAs that we have moved will not affect the operations of the Legislative Council. And Chairman, I therefore believe that the Bills Committee can deal with this issue, and there is no need to consult the views of each and every member of this council. We have never had any precedent of doing that before, namely consulting the views of electrical members. We don't understand how this procedure could be initiated. If members have contrary views, then we can certainly discuss those differences of view at this Bills Committee, and then report to the House Committee, and if the House Committee accepts the report, members can still further debate the bill when it is read in the Council. Chairman, I believe my colleague has something else to supplement. Chairman, when we drafted Section 6 of the bill, we had deliberately stipulated which are the procedures which will be covered by this bill. Any proceedings which does not come under Section 6 will not apply. The bill will not apply. The legal advisor has raised a question. Now, as far as the administration is concerned, we do not believe that Section 6 of the bill would apply to the Legislative Council. All along, it has not been our intention that this bill would apply to electrical. The text of the bill would not give rise to any conclusion that it would apply to the Legislative Council. Since the legal advisor and members have this concern, we've therefore made a technical clarification. This is a very common technical clarification. It is not that we are making a major amendment to the bill. We've not amended anything in the bill. We're just making a technical clarification here. Our understanding, according to experience of drafting many bills, that for such technical clarifications, normally there would not be any need to deliberately consult all 70 members of this council. Well, this is unprecedented. Regarding the present proposal, we don't understand. We don't know what's going to happen if we were to implement this option, and if we were to vet other bills proposed by us, what will be the impact? Now, having heard the discussion so far, my understanding is that if with the CSA now, then normally this will be discussed when we go to the committee stage debate. So there is therefore no need to take that extra step to consult the views of all electrical members. Now, I understand our legal advisor may need to further supplement on this point. Or you'd like to say something first? I understand. Let me read out the names of those members who've already put up their hands. Fine. We've just heard our legal advisor and in administration explaining whether or not this would apply to electrical proceedings. On the subject of whether or not the provisions in the bill applies to this council, 3 members have indicated they would like to speak. James Toh, Dr. N. Jiang, and Priscilla Leung. On this point, are there any other members who would like to speak? Well, we just started our discussion with Section 8.2. Yeah, certainly you can. All right, Claudia Mo. Anyone else who would like to? Mr. Chung Kwan as well. So we have 5 members: James Toh, N. Jiang, Priscilla Leung, Claudia Mo, and Chung Kwan, who would like to speak. Our legal advisor, is there anything else you'd like to add? Perhaps I'll wait until members have spoken first. So, all right, we'll begin with Mr. Toh. Chairman, I also have some experience scrutinizing the government's bills. Of course, there's always the question of degree and extent, but the point is that on the question of whether or not a certain procedure applies to a particular department, if you add this to any of the courts under the judiciary, I'm sure the government must have consulted the judiciary first, because they are very concerned about that. Just imagine that you would take the previous commissioner or take him out or include him. Certainly you would have consulted him, of course. When you drafted the bill, of course you would have consulted him. You want to cover the previous commissioner as well. Now, if you ask the government, although they've listened to members, applying the provisions of the bill into this council, well, we are a statutory body. Therefore, I think the proper procedure should be that, now I say this, I don't know whether we should be all 70 members. Now we have electrical members present here, but those present today may not be the same as members of the members' interest of committee, or the other members may not think along the same lines as we do. So I think we should have a paper, say, informing all members about this issue, and then we can. I don't think it would take up a lot of time. The government, of course, say this would set a precedent, but I believe we already have such a precedent. If you don't consult the judiciary, and all of a sudden if you don't consult the previous commissioner, I'm sure you have consulted them. So it's as simple as that. So you don't need to worry that we are setting any precedent here. Thank you, Mr. Toh. Dr. An Jiang. Chairman, according to the law, I agree with the law draftsman, but however, it is also undeniable that whether the provisions will affect LegCo members, actually we don't mind. Well, I think we can certainly, inform the other members, circulate the proposals to other members, and then if there are any views from our colleagues through you, Chairman, we can relay them to the law draftsman. We will also be discussing this when the Council deliberates on this bill. So at this stage, I don't think we should take this to the full Council. But I agree that we should circulate this to all 70 members of the Council. Dr. Priscilla Leung, thank you. Members who have joined this Bills Committee represent different political parties, so they should be quite representative. As members of this Bills Committee, we have a duty, which is that if we believe that this is an issue which affects other colleagues of the Council, we can certainly take this back to our respective political parties and discuss that. We've done most of that at the Rules of Procedure Committee. For every issue, we will consult members of our political parties. When will we need to consult all members of the Council? That would be when we have to conduct public opinion. At this stage, I don't think we need to consult all LegCo members. As members of the Bills Committee, I think we can play our role. That is, we can consult the views of our party members. We are the members who know the most about this Bills Committee, and if we consult the other members, they may not really understand the bill as much as we do.
And on this issue, I do have an opinion, and I would accept the government's recommendation. But as for the views of the legal advisor, I can discuss with my fellow members in the party, and I'm sure they would accept my view in accepting the government's proposal. So at this stage, I think this is what we can do. As for the views from other members, I think you can consult them. But my opinion is that members who are not involved in this Bills Committee might not be able to follow our discussions over multiple meetings. And what they have in mind, would they be able to follow what we are discussing? If we discuss this issue at the committee stage, it might not be the most effective. That's why we are trying to gather everyone's views today. Ms. Claudia Mo. Hong Kong relies on separation of powers, executive, legislature, and administration. And the legal advisor said that the bill should not apply to LegCo proceedings, and I absolutely support it. LegCo should have an independent constitutional status. When I look at Clause 6(1)(a), and it says it would apply to disciplinary proceedings. We have a personal interest committee at LegCo, and if the apology the apology legislation applies to LegCo, you can use this piece of legislation in the UGL Select Committee. You can say that your apology would tarnish the reputation of your party, etc. So there would be a political impact or ambience, and perhaps we will not criticize you as much. Please do not walk back and forth in front of me. So there will be a political impact, and I do not agree. In my opinion, LegCo should still be an independent body, but some people would question whether this would be able to override the LegCo proceedings or ordinance, and this is not the case in other legislations or jurisdictions. Or else, if everyone makes an apology, we would not need to do anything, at the CMI or PAC. It's not necessary to discuss the issue with all members at the committee stage, but I agree with Dr. N. Cheng that you should inform them of this issue. The government said this would not apply to LegCo proceedings, and after a debate, you said that they should be applicable, and this doesn't give a good impression. So, what are the justifications of this legislation not applying to LegCo? In other countries, no explicit provisions are required, and you are concerned about Clause 6, and I agree with your CSAs. Thank you. Next, Ms. Horace Chang. Thank you. As the administration have said, this is a clarification. Well, this was not the focus in earlier meetings. We were talking about Clause 8, Brackets 2. But I think such doubts were valid on whether the legislation should apply to LegCo proceedings, and the government clarified that the legislation would not affect LegCo proceedings. At the committee stage, well, it's certainly feasible, but is that the only solution or approach? Are we going to discuss everything at LegCo at the committee stage? You are not wrong, but there are other approaches to achieve the same means. As other members said, we can inform all members, or they could be invited to the Bills Committee next time to give their views. These are all possible. And every Wednesday and Thursday, we have a very packed agenda. Well, for a less controversial issue, if it's to be included, if it will be debated at the committee stage, then there would be, the schedule on Wednesday and Thursdays would be even more packed. So we should instead inform all members and invite them to the next meeting to give their views. I think the same goes for other LegCo committees. Members are free to give their views. I think this would be more effective. Next. Mr. Dansquo. Thank you. The proposal is to exclude the apology legislation on LegCo proceedings. This should be the focus, and the idea is to respect the special status and privileges of LegCo. That is the government's intention. I am sure none of the 70 legislators would object to that, because it is done out of respect by the government. If this legislation is to apply to LegCo proceedings, then this would become a common concern for all legislators, but this is not the case. So this is a sign of respect on LegCo's powers and privileges by the government. I don't think any legislature would stand against that. If any member feels that through the House Committee or ROP Committee that members should be informed, then they can be invited to this Bills Committee. When we are scrutinizing the bill, we should not create a new procedure elsewhere. I think this is unnecessary. If the Bills Committee finds it appropriate, at the next House Committee meeting, we can invite the House Committee chairman to inform members of this issue. So you can do it next Friday. You can ask the House Committee chairman to inform members of the HC and invite them to the Bills Committee if they are interested. I think this would be most effective, procedurally just, and we can invite members to the Bills Committee if they are interested. Next, Mr. Felix Chung. Thank you. We acknowledge the legal advisor's view, but do we have to consult all 70 legislators? I don't think it's necessary. A lot of members who are not taking part in the discussions do not understand the bill. But we have to inform members of the legal advisor's stance. So I think we should inform them via the House Committee or by other ways such as circulars without affecting the progress of the scrutiny. I think this would be enough. I understand the government's concerns on whether the proceedings would be lengthened. So I think it's enough to inform other members without affecting the progress of our scrutiny. I've heard views from members in the first round. Apparently, members tend to agree that the Apology Bill should not apply to LegCo proceedings because the government respects the independence of LegCo. So the bill would not apply to LegCo proceedings. This is something members tend to agree on. And secondly, whether or not we consult other members, we can instead just inform other members. We have members of the Bills Committee here today, but members who are not part of the committee might still need to learn what happened. And I see that members prefer to inform members, and that would be enough. And that would not affect the progress of the scrutiny. If this is something we agree on, I like the legal advisor to talk about the procedures to see whether this is possible. So how can we inform members without affecting the scrutiny of the bill? Legal advisor, please. Well, I talked about all members. Perhaps it was a bit misleading. I'm not talking about the committee stage of LegCo. I'm just referring to the 70 legislators. For the committee stage, there would be a resumption of the second debate of the bill anyway. If the Bills Committee finds it necessary to inform or consult the other 50-odd members, I think issuing a circular would be enough. And we can attach a paper from the Legal Services Division to explain the background of the bill and the legislative effects of the CSA. So we do not know whether they have any views on that. I think this can be done concurrently with scrutiny of the bill at the Bills Committee. Then there's no conflicts. Whether we need to consult the other 50-odd members, this ultimately is the decision of the committee. So we have taken in view some members in the first round. I think the most straightforward approach is to issue a circular. And as members suggested, we can simply inform members without affecting the progress of the scrutiny. I tend to believe that according to views from members, the apology bill would not apply to LegCo out of respect towards LegCo's independence. So I'd like to see if there's any objection.
If there's no objection, then perhaps we can ask the Secretariat to draft a simple circular to colleagues and to inform them of this matter. I think this is the most appropriate way to deal with this issue because it will not affect the our scrutiny of the bill. So let's now come back to our discussion on Section 8, Bracket 2. And with that, let's now come back to Section 8.2, which is about discretion. I understand that some members already put up their hands. I'll read out the names of those who want to speak in respect of Section 8, Bracket 2. Dr. N. Jiang, Claudia Mo, Mr. Leung Kai-Chiang, James To, Chung Kwok Kwan, Priscilla Leung. Are there anyone else who would like to, discuss the question of discretion? If not, I will allow each member 4 minutes to speak on the subject of discretion. If any other members would like to join the discussion, please put up your hands. Dr. Chang, Chairman, during the public hearing, we have heard that the public in general welcomes the enactment of the apology bill. But many of those present had expressed concerns. They pointed out that if the bill is too abstract, if we are silent on many things, then, as in the case of doctors, for example, if unfortunately the patient dies and the doctor needs to explain why the patient dies and explain that to his family, if the statement of fact should be included in the apology ordinance, they would be even more worried. But if the family of the deceased are already very sad, but you don't explain to them the cause of death of the patient, if the doctor doesn't elaborate, on the cause of death, the family may feel that they are not given an answer. They will not feel relieved. So, and this is not conducive to the amicable settlement of any disputes. And many deputations even suggested or asked, they pointed out that if you include the statement of facts, how would you protect the person who makes the apology? But the administration said if we go for the absolute protection of the statement of facts, it might conflict with the basic law. Another option they proposed was that if we protect the statement of facts subject to exceptions. In other words, there are circumstances. I mean, this would take us back to the question of discretion. According to the CSA, they use the term any relevant circumstances, which basically amounts to the same thing. I don't have time, Chairman. I'd just like to give another example for our law draftsmen. For people who belong to the underprivileged, if they don't have any evidence at all, and when the other party said something in the course of making the apology, and the judge exercises his discretion and accepts that as evidence in the absence of other evidence, if you stipulate in the bill that the person making the apology, then he would not say anything else. So in that case, how can you protect the party?
事實陳述呢一個 ，OK。
Without the statement of fact, the person making the apology, when he apologizes, may, provide more details, and the party can actually search for further evidence based on the apology that is made by. So you want to, protect the party, the underprivileged, ensure justice is done, then the statement of fact cannot be included in the apology ordinance. Before the apology ordinance can achieve the original intent of the bill. I think Ms. Chang is very concerned about this bill, and
呢個方面我諗睇下法律顧問啊，sorry 對唔住，可唔可以政府嘅代表睇下可唔可以再
Could the administration perhaps would the administration like to respond? Is there any way you can allay Dr. N. Jiang's concern, which she raised at a very early stage already? I don't have any question, Chairman. 4 minutes. Yeah, she's finished. Chairman. May I suggest that we listen to all the other colleagues, members, before we respond? Okay, sure. Ms. Claudimo, I understand that Section A2 of the bill, if it were deleted, we may as well do away with the entire bill. Now you are providing for more details, and that is a good thing. But I still have one concern. That is the decision maker. Now, of course, this person could include the judge, could be the judge or the presiding officer of a tribunal. But if you say any other organizations or individuals, the decision maker includes the arbitrator or any body or individuals, so long if he has the authority. So the decision maker could be a layman. Of course, you may require him to seek legal advice, but his decision or judgment. Now, if you're saying that if somebody exercises his discretion. If somebody feels aggrieved, then he can challenge the court or the appeals tribunal. Now, the decision maker is a layman. I think he is not being fair. If I want justice done, I would need to go back to the court to seek redress. Now, regarding this process, would it be unfair to the person who feels that he is aggrieved? And secondly, with the passage of the bill, you will monitor the operations of Section 8.2 and you will conduct timely review. What is your typical timetable? How do you monitor the operation of any provision of the bill? Would you keep record of each and every case and review them? Mr. Khan will respond after all members have spoken. Mr. Leung Kai-chiang, James, Priscilla Leung. Thank you. Regarding Section 8, bracket 2, I think we always have a contradiction here. During the public hearing, Mr. Choi Yu-chung pointed out that if we take away Section 8, bracket 2, they would not accept that. Some deputations are very concerned about Section 8, bracket 2. As far as the enforcement of the law is concerned, we believe that the discretion may create a lot of uncertainties. And when the parties ask the lawyers to be safe, when they ask whether the party should apologize or not. Now, the purpose of the bill is that we want to encourage more apologies. In the end, people dare not apologize. And that is contrary to our purpose, our intention of promoting apologies to settle disputes which could be resolved. In your amendment, you make reference to public interest and administration of justice. Well, I can accept that personally. From the legal point of view, I think the scope has been narrowed. In the Chinese version, you say public interest and administration of justice is similar to just and equitable, except that you've added public interest. For B, I don't feel so comfortable with B. You say any other circumstances, you say. Any other relevant circumstances. Again, the scope is very broad. You've narrowed it here and then you open another door elsewhere. If you have deleted B, then I can seriously consider your the public interest and the administration of justice argument, because in common law there are case laws that we can discuss and principles that we can invoke. You cannot lightly invoke that. So you need to be more focused. But I don't agree with B. If you're not a lawyer, then it may be excusable, but many people would say that this would not give any assurance or confidence to the person making the apology.
好，咁幾位委員都問咗，咁不如
Several members already asked the question, could the administration give a global response here? And some members have also suggested that you should further tidy up your CSA. Any response to that? Thank you, Chairman. There are several points here. First of all, whether the statement of facts should be included in the definition of apology. I think we can all remember the public hearing on May the 9th. In a paper, we also said that for all the people taking part in the public hearing were agreed that in the apology should include a statement of facts. We don't want vague and abstract apologies which may be counterproductive. I think this is what we heard at that hearing. I believe members would note that. We hope that we will be able to address the concerns of the public. We want to be able to help them so that they will get an apology that they are comfortable with. That is our principle. We want to encourage parties to make genuine, sincere apologies. And that's why we've included the statement of facts. Regarding the second point raised by Dr. Priscilla Leung, which is under Section 8.2, do we need to add Section 2B? When an incident happens resulting in someone having to make an apology, I mean, each incident is unique in itself. There are unique circumstances. When we enact a piece of legislation, we cannot be too rigid. Otherwise, there might be a very exceptional incident. And other than public interest and the administration of justice, there might be very exceptional circumstances where we may need to give special consideration. We just don't want, we want to ensure that in 2 and 2B we explain what is fair and equitable. That is the broad principle. So even if we provide for 2B, it would have to be compatible with the principle of fair and equitable. It would not be just anything. We hope members will understand that what we're trying to do is that under the principle of ensuring everything is fair and equitable, there should be guidelines so that the decision maker can judge whether or not it's fair and equitable and take into consideration the special circumstances. That's the rationale for including 2B here. Ms. Mo asked whether the decision maker may not have sufficient legal expertise to make a decision. Sorry.
Assuming that I'm the aggrieved party, my impression is that the decision maker is not a judge. It can be anybody or any individual. When I launch an appeal, I have to go to the court or appeals tribunal. So would the procedure be unjust? I would try to address that. There are calls to for all these issues to be dealt with at the court, and would that be fair to both parties? And for an administrative appeal or disciplinary inquiry, if such problems arise, then a new case has to be taken to the court, and the judge has to consider the case again. When the matters are taken to court, then lawyers would have to be employed, and more time would be consumed. Usually, the process would be suspended for the court to decide whether discretion would be given. And at the court, lawyers would be involved, and the court needs time to decide as well. Our concern is that if all matters are taken to court, it would be expensive for both parties, and it's also time-consuming. Under the existing procedures, the more important the procedures, usually they would be handled by individuals with a legal background. For example, at the medical council or the administrative appeals panels, etc., the members are usually solicitors, barristers, or retired judges, and there would be legal advisors. That's why we feel that the decision makers are capable of dealing with these issues, as Ms. Mo suggested, for those without a legal background. For example, disputes among owners' corporations. For owners' corporations, they might have legal advisors. If they don't, they might be dealing with cases with slighter consequences, and decision makers would often decide whether or not to admit certain forms of evidence. So I feel that the decision makers are capable of dealing with such issues. For more important procedures, they would be managed by those with a legal background or legal advisors. If we eventually have to take the cases to the court because of this, for example, for cases involving owners' corporations, they might have legal advisors. But if these cases have to be resolved in court, that would complicate the proceedings, and that might not be just for both parties because they need to spend a lot more time and money. Thank you. He has not addressed my other questions on how you can monitor the enforcement of the bill, the review schedule, etc. Anything to add from the administration? We can wait for the second round. We will certainly monitor whether judicial means are required. If the bill is passed and the policy objectives are met, and that we see more apologies that incorporate statements of facts, and the statements of facts might not be admitted as evidence in civil proceedings, we will monitor whether such issues arise, and every now and then we will conduct a review. We will contact stakeholders including the Law Society, the Bar Association, etc. So with such information, we will monitor the enforcement of the ordinance, and we will listen to different bodies and see whether we are fulfilling our policy objectives of promoting apologies and minimizing disputes and providing quick resolution of problems. Mr. Horace Chung raised his hand. Mr. Chung, would you speak in the first round? 4 minutes. Chairman, we would like to add to the issues, on some of the issues. I'd like to address Dr. Priscilla Leung's comments on our proposed amendments. As I said, our amendments took reference from the mediation ordinance. So I'd like to read out the relevant provisions in the mediation ordinance. Under the MO, there's similar wording as Clause 8(2) of the bill. In the MO, they talked about whether mediation communications can be disclosed and whether courts have to deal with these. And there are several aspects. The two of the aspects are being considered by us, and it says when disclosing such communications and considering the admissibility of such communication, they would consider public interest and whether administration of justice. And under Clause C, it says the relevant tribunals and courts. Well, all the issues considered by these courts and tribunals. So the spirit is similar. So I hope members can consider such wording under the MO, so members can take reference from that. Ms. Horace Chang, thank you. On Clause 8 brackets 2, this is the main area of interest from members, and the administration is trying to alleviate our concerns. This is something I acknowledge. To be honest, I have not looked into the amendments in depth, but I hope the administration can provide more information. For all relevant circumstances, the scope is very wide and indefinite, and after the amendment, and under A brackets 2 brackets A, it would be in the acting in the interest of public interest and administration of justice. So the issue has been clarified. But together with brackets B, any other relevant circumstances, and after you create these brackets A and B, the overall picture seems to be similar. It used to be called all the relevant circumstances. Now it's expanded to A and B, but still it's very indefinite. So how should I interpret these amendments? As Dr. Priscilla Leung suggested, if we take out B and just have A in the public interest or the interests of the administration of justice, then we won't need to include any other relevant circumstances. Would Dr. Leung and Mr. Chung accept such proposal? Perhaps the administration can elaborate on that. Thank you. I will try to elaborate on that. As we said, Clause 8.2 applies to exceptional circumstances, and it's hard for us to say now what those exceptional circumstances will be. And the incidents leading up to an apology are all unique in nature, and the statements of facts might be very complicated. So it's hard to say for sure at this point of how it will be deployed in the future. That's why we decided to add Clause 8 brackets 2 brackets B. We want to deal with we cannot understand what would happen in the future if we are being too definite. We cannot cover possible exceptional circumstances in the future. And under the principle of just and equitable, having considered public interests, if certain exceptional circumstances could not be foreseen, then we would allow for such flexibility under Clause 8 brackets 2B. So that is the intention of brackets B. Under the mediation ordinance, similar provisions are in place to specify when the communications can be admitted. We know that the MO has been invoked from time to time, and there are no comments from the trade on the on possible difficulties in enforcing these terms. I feel that brackets B already encompasses brackets A because public interest or interest of the administration of justice has been included under any other relevant circumstances. Mr. Michael Tian, 4 minutes, please. Chairman, I dare not to speak because this issue is very complicated and we're not sure whether we should go ahead. And if we go ahead, there are a lot of limitations. We are now discussing the scope. In Scotland, when they discussed the apology bill, they adopted absolute protection on the statements of facts. But someone gave an example: if a driver injured a pedestrian, or a child, so absolute protection is not possible. So the problem is the scope of applicability. Now, under the amendment, you have subclause 2A and 2B. I agree with members that 2B will force apology makers in the future to just say sorry and nothing more. My lawyer friends said you should not say anything, so I think B must be removed. Chairman, if you ask me, when I see subclause 2A, if I want to apologize, but people say that if I don't say anything else, I should not, rather not make an apology. But what I say is in public interest or in the interest of administration of justice. My friend says it's hard to say because the it's too wide-ranging and we do not know what the judge would think. So perhaps on second thought, I would just say sorry only. And my friend says if you only say sorry, you might achieve a counter effect because you might be accused of not being sincere. So eventually I decide not to do anything. So we're back to square one. There's no point of doing all these. So my view is I do not want B or even A for that matter. In the presence of other evidence, they could be admitted. So this is the only exceptional circumstance we understand at this point. Why can't we take that as a starting point instead? So for apologies with statements of facts, well, if the means can be achieved by other forms of evidence, and the apology maker can still defend other forms of evidence, but at least we have a starting point. So with this, I think more people would be willing to apologize, and the statements of facts would be fuller. Or else, I think even with the enactment of this bill, nothing will change because you are not tackling the problem. That's my thought.
So I don't want A, I don't want B, I don't want A either. I think the only exception, there's only one exception there. Now, if we start with such a narrow scope, would you rather not to enact the bill at all, Chairman? We definitely will propose to let go that the bill be passed. Our policy is to, minimize disputes and ensure that there will be amicable settlement of disputes. Concerning the example given by Mr. Teen, now if we are going to delete B and A, and if the person making the apology, if he thinks that he has the evidence and he can apologize. But again, there would be another concern here. So what is meant by evidence? This may be difficult to define. It may also affect whether determine whether a person should give a genuine and sincere apology. What the bill proposal now can really help achieve our purpose. Let's not just be, bogged down by the phrase any other relevant circumstances. One would need to look at the overall proposal, especially for Section 8, we say that it will only apply under exceptional circumstances, which may include the scenarios described by members. That is, under normal circumstances, when there is normal evidence in place, whether it's a lawyer or the person making the apology, they can, with the help of this bill, make an appropriate apology, including the statement of facts. And that's not difficult to do under normal circumstances. And it's very difficult for us to think of any exceptional circumstances. That's why some members mentioned the need to protect the underprivileged and those whose rights are being infringed upon. We want to protect the legal rights. So this is our objective. We want to come up with a bill. Don't you think whether it's easier to know whether there's any other evidence than considering public interest? You're just trying to encourage me to apologize. Well, I think this example will still be there. Well, I just want to limit it to this as a starting point. Well, I also like members to apologize, to consider that the person making the apology, when he apologizes, he make a statement of facts. He will not lose out because in any civil proceedings, such evidence, the parties to the proceeding has a duty to make such disclosure to the other party, whether the evidence is, favorable to him or not. On that basis, he's just, bringing forward the statement of facts to the other party, and doing so by way of an apology will give him the protection. And the apology and the statement of fact in the apology will not affect the disclosure of evidence. It will only let the other party know well in advance. And well, why don't we start from there? Why do we need to have A and B? The reason is that there are exceptional circumstances. For example, when there's no other evidence, or there are other circumstances that we can think of at the moment. Members may say we will only put this in when we can think of those exceptional circumstances. But looking at some of the case laws, there are two CFA case laws involving bankruptcies. The law was the ordinance stipulate that the person who is bankrupt, normally the bankruptcy order will be revoked after 4 years. But according to the earlier ordinance, if the bankrupt person is not in Hong Kong, it will not. Those count as part of those 4 years. The CFA's ruling is very rigid. So if that person may have very good reason not to be in Hong Kong, he could be sick elsewhere and cannot come back to Hong Kong, or there might be other reasons why he cannot return to Hong Kong. It's due to no fault of his. But the ordinance is drafted so rigidly, and the court will have no way to waive the enforcement of the ordinance. So the CFA ruled that the provision in the bankruptcy ordinance was unconstitutional. Applying that principle, if the law is drafted very rigidly, which resulting in injustice, and the court cannot deal with that because the court will need to follow the provisions in the law. If the law does not allow for any discretion at all, what the court will do is that the court may think that the existence of that piece of ordinance is not fair to one of the parties. The court may then rule that it is in violation of the Bill of Rights, and rule that the ordinance is not valid. So what we are proposing here is to allow for some discrepancy for the. And because in the mediation ordinance, we do not stipulate that the court will only have an exception under one specified circumstance, so that the court can, make a decision in the light of the circumstances of the case. We have one more member who would like to speak, Mr. Jonas Ho. Chairman, I'm slow in putting up my hands usually because I have to listen to the other colleagues first. For Section 8, you've added subsection A and B. Well, I don't think it really helps at all, because the decision maker has the discretion, that is, in the absence of any other evidence, when the person said this, then this could be one of the factors to consider when he makes a judgment. And that's why people might be worried that whether he should apologize or not. The spirit of 8(2), whether you've added A or B, it would not be very different from the original Section 8(2). We're talking about public interest, upholding, justice. What I'm most worried about is that what is the relationship between Section 8 and Section 10? For Section 10, bracket 2 and 10, bracket 3, you are apparently saying that whatever happens in future, should there be any apologies, it will not affect the insurance coverage taken up by the party. The insurance company will not say this silly man made this remark, he didn't make that apology, nothing would have happened, but he made the apology without the insurance company's agreement. It will void the insurance contract. And Section 11 would deal with this situation. That is, if the party said this, made an apology, it will not render his insurance contract void. That's what Section 11 said. Section 12 said that once the bill became law, all the guarantee would retire. But if there's anything contrary to Section 10, it will still have, it will override those others. For Section 8, where do you 8 bracket 2, where do you add subsection A and B? Now, if the decision maker exercise a discretion resulting in the party not being able to enjoy the protection under 10(1)(2)(3), if the decision maker said, "I'm sorry, Mr. Ho, you said this and that, and I will take that in consideration in my judgment." So, if that's the case, well, if I said something then, and I'm now held liable for that, but I've taken up my insurance policy, it would not be the case that because of 10 bracket 2, then 10 under Section 10 bracket 1, 2, 3, would it be able to cover the scenario I mentioned earlier? If I may answer Mr. Ho's question. Mr. Ho has explained this very clearly. You were correct. Section 10 bracket 3. If we go to the English or the Chinese version, it will be a lot clearer. It says here that this section applies despite anything to the contrary in any rule of law or agreement. In other words, if there is even if there is another provision which is totally contrary to this particular rule, this section will override the others. So since it has, so what you're saying therefore is correct. Whether it's anything happened under Section 8 bracket 2, whether the court rule that the statement of fact should be accepted as admitted as evidence or not, it will have no impact on Section 10. Chairman, that is very important. If you allow me to elaborate further, I'm worried that if there is contradiction among the different provisions in the bill, we will have to ask which one will override the other. Ada is now saying that he referred to the other sections which are not in this bill, and that would then I would find this acceptable. Last time I said that for the avoidance of doubt, Section 10 shall prevail, notwithstanding the fact-finding and so on and so forth, under Section 8.2. I had once wanted to move such an amendment to allay members' concern. If I'm held accountable because of 8.2, I'm worried that I still have my insurance coverage will be voided, and then I will have to bear an owner's responsibility. Now, this is a question relating to jurisprudence. Why is it that Section 10 should prevail over Section 8.2? What is the basis for that? For any rule of law, I thought that in the same rule, why is it that 10 would prevail over Section 8.2? Yeah, perhaps I can clarify this point here. Other than this bill, we have the Interpretation and General Clauses Ordinance. In that ordinance, there is a definition for what is a provision, what is a law, and what is a provision. It would include any provisions in an ordinance. According to our present draft, it is clearly stated that for any rule of law, even for this bill or other ordinances, and it's not just ordinances, there are also the spirit of the common law, which is also included. So everything is included. Ada, I'm a lazy man. Could you give me, show me the proviso later. And finally, I don't think we need to add the CSA. Just under Section 10, you add a subsection. Subsection 3, you can extend it saying that notwithstanding 8(2), 10 would still apply. Do we need to do that? I think we can dispense with that. The present provision can already address your concern. Thank you. Very pleased to hear that Mr. Ho's concern about Section 10 can now be addressed.
Mr. Horstrand would like to speak for the second round. Just now, we spent quite some time discussing the new wording under Clause 8(2), and some members also offered their views on whether brackets B should be deleted, etc. I think the discussions on Clause 8.2 must continue. But we can actually begin the clause-by-clause examination of the bill to cover the less contentious provisions first, so in order to expedite our work. Barring any objections, we would allow Mr. Horstrand to speak in the second round before we begin the clause-by-clause on the less contentious clauses. We will continue our discussions on Clause 8(2), and I trust that the government would think about our comments after the meeting. So, Mr. Chang, please. So, in the clause-by-clause, are we going to be stalled by the time we reach Clause 8? We would shelve Clause 8 for now and allow other clauses to be passed first. That way we can proceed to the scrutiny sooner. Mr. Horstrand. We have discussed Clause 8(2) for many times. I think the public does not really understand what we are discussing. Well, I'd like to offer a summary of the progress so far. The administration wants to pass this bill because in the past, apology makers were wary of liability. So through the apology legislation, the government wants to encourage apologies in order to avoid unnecessary litigations. That is the intention of the bill. So basically, all members would agree with such principle. We are at a stage in which under Clause 8, the administration cited exceptional consequences or circumstances in which the statements of facts within an apology might be quoted or used against the apology maker in the future. So this is in conflict with the intention of the bill. You might talk about public interest or administration of justice, and that exceptions might be given. Under Clause 8, you admitted that the no one knows what those special circumstances might be. You can only give examples, but they are merely examples. So as Mr. Michael Tian said, his lawyer friend, that given the uncertainty of the special circumstances, no one would dare make apologies, or they would simply say sorry. If the bill is passed, is the administration confident that in most cases people would not be afraid to make apologies? Or would you say that you are not certain? As a legal practitioner, I'm afraid that you are just going through the motion by passing this bill. Would it be effective in the future? I have my doubts. So that is the latest position. So I'd like to know the administration's views. So Mr. Chung has effectively summed up our discussions thus far. So the public would understand what is going on. Can the administration give more? In an extreme case, if we take out A2, or if we take away all discretion according to the paper, by the time the case is taken to the court might refer to cases from Canada. Even if you do not explicitly provide for discretion, then the court might think otherwise by quoting Canadian cases. So would this be an element of uncertainty? Thank you. I will try to address the first question. The main concern is that Clause 8.2 imparts uncertainty. So we must first assess whether such factors of uncertainty are highly problematic. We can first look at Clause 11. It says this ordinance does not affect the discovery or similar procedure, and such procedures are clearly defined. Both parties to a litigation are obliged to provide all relevant papers and information on a dispute, whether or not those information or materials would help or stand against them. They are obliged to disclose such information. So we should see how often we need to invoke the statements of facts in an apology. In most cases, the apology and its statement of facts would state the details of an incident, and these details must be given anyway during the discovery procedure. And during a litigation, how likely are we to invoke the statements of facts in an apology? We do not think that this is likely. Given the low likelihood, we should first clarify the issue or uncertainty to see whether it's as wide as we thought. As we said, we need to balance the interests of both sides. On one hand, we have to protect the apology maker, but we understand that we cannot violate basic human rights in our ordinance, or else the courts might deem the ordinance invalid. So this is the balance we are trying to make. We want to protect the apology maker without being challenged in the future of being unconstitutional or in violation of any basic human rights or Bill of Rights. So we have already achieved this balance, and we have specified that only exceptional circumstances would be covered, and we gave some examples. Not all exceptional circumstances would allow statements of facts in an apology to be covered, and the decision maker must be satisfied of the just and equitable principle and the 2 points we discussed. Only then will the decision allow such statements of fact to be admitted to court. So such uncertainty only applies to very extreme circumstances instead of ordinary circumstances. We do not think that there would be great uncertainties. My colleague has something to add. I'd like to address the chairman's question on the cases in Canada. In our paper 3-41085 section 17-02 in paragraph 11, this has been mentioned. If we afford absolute protection, if the court deem the absolute protection to have violated the BOR, then that statement of fact is the only piece of evidence. The court might deem that if the evidence is turned down, then it's a violation of human rights, and it might be ruled as unconstitutional. But the court might have different interpretations. But if we do not have Clause 8(2) at all, then according to the court's understanding, it's an absolute protection, and the court will likely rule the provision unconstitutional. In that case, the court has to consider case by case. With a lack of Clause 8(2), the court has to consider case by case whether the statement of facts should be admitted. So this is similar to the Canadian practice. If a person includes statements of facts in an apology, in case of dispute, the court will decide case by case on whether the statements of facts constitute part of the apology, and the court must make a decision after hearing from both sides. The uncertainties would actually be greater. Our proposal can avoid the possibility of being unconstitutional. And the court, if the court rules on the statements of facts case by case, the uncertainties would be high, just like in Canada. If a member of the public makes an apology expecting absolute protection, only to realize that the the court rules that absolute protection is is against the Bill of Rights, and the court would assess whether the statement of facts constitute an apology, and I think this is something members can consider, even if we say there is absolute protection, but it might not be so in reality. As we said, barring objections from members, we need substantial time to discuss Clause 8.2, so perhaps we can begin the clause by clause to look at the undisputed clauses first. For Clause 8.2, we can discuss more later. Can we invite the administration to begin the clause by clause examination? Chairman, so what are we going to do with Clause 8.2? More time is needed to discuss Clause 8.2, and more time is needed to understand it. And having taken in views from members today, we have basically entered the clause by clause of the bill. We can look at the less contentious clauses first, and we can come back to Clause 8.2 later for further discussions. So first, we will allow the less contested clauses to be passed first. I think more time is needed to discuss Clause 8(2). Chairman, according to Ada, you said statements of facts are not likely to be invoked, given the low possibility or even impossibility. With Clause 8.2, apology makers might be discouraged from making apologies. I think this is the crux of the issue.
We're not saying that we want to insist on anything. We hope that for any piece of legislation, after they have been scrutinized and enacted by this Council, it will be an effective piece of law which can achieve the original legislative intent. Otherwise, it would be a waste of our time. It would also, I think it's not just the legislation itself. We really want to have more harmony in our society. So if people really has made a mistake, then they should apologize. So I hope the existence of 8(2) will really, be a disincentive. You've not said what are the situations in which where the statement of fact will be cited. You also said that it might be unconstitutional. And you even asked whether or not it will be in breach of the Basic Law and the Bill of Rights. All these are unknown factors. You're only telling us what are your estimates. So I don't think we have been convinced. Is there any further response from the administration? We've heard members' views. We are grateful for your detailed inputs relating to Section 8(2) and how the discretion should be exercised. We understand your concerns, but I hope members would have also heard that we've made a very objective legal point as to how we can strike the right balance. I hope members understand. We've said on many occasions already that we've spelled out clearly that the exceptions, even if there are exceptional circumstances, we need to satisfy the principle of fair and equitable. When the lawyers and the legal professionals see this provision, they would they would all know that the discretion will only be used when it is fair and equitable to do that. So this will give greater confidence for the members of the public if they need to make an apology. And they will also better know what will be the consequences. So thank you. So members have already expressed their views. You can go back and consider those views. And Dr. Chang earlier on also expressed her concern. So perhaps you can go back and further consider her points. If there is no objection, we will ask the administration to, take us through the bill clause by clause, starting with the long title. It is our purpose to make provisions regarding apologies. The purpose is to promote and encourage apologies in order to promote the amicable settlement disputes. Section 2 is the commencement date. Thirdly, Section 2, object of the ordinance, which we've already explained earlier. Section 3, interpretation. Apology, applicable proceedings. And for this we need to go to Section 4, meaning of apology. Chairman, regarding Section 3, what is the difference legally between the term apology and regret? Chairman, we have a broad definition for apology. We hope that this can help achieve the intent of this bill. So different forms of expression would be included to allow, flexibility for people to make that expression of apology. Regarding regret and apology, under Section 4.1, we've already, spell out our intent. Mr. Chang. No, he's not answered my question. I heard you wanted to clarify the difference in the definition of apology and regret, right? In English, the term is apology. In Chinese, it's translated as 道歉. But 道歉 in Chinese and 抱歉 are not the same. Regret, that is. So legally, is there any difference in meaning between the apology and regret? Perhaps you can give me an answer after the meeting. Yeah, I think we can explain that. Under Section 4, subsection 1, we have defined provided for, spell out what apology would include. We've extended the scope of the meaning of the word apology. If Ms. Chang go to the last line, you'll find that it would include an expression of the person. So whether it's apology or regret, it would both apply. Ms. Chung, are you happy with that? My understanding is that they provided for a very broad definition. They say in this ordinance, an apology made by a person in connection with a matter, blah, blah, blah. So what exactly is the difference between apology and regret? I just want to know. Perhaps our legal advisor can explain. This is for Ms. Cheung's reference. Regret is one term. It is translated in 3 different ways. 歉意、懊悔、遺憾. I've looked up the dictionary, the Chinese lexicon. According to the Chinese lexicon, 歉意 means you are sorry. 懊悔 meaning you don't feel comfortable because of the fault that you've made, and so the big difference is 懊悔 in Chinese implies fault on your part. Regret or sorry may not imply any fault. So the person said, I'm sorry, I was careless, I knocked you down. For this, I'd like to say I'm sorry. So that would be expressed by regret. That would come under the definition of apology. Yes, yes. But our law draftsman would also like to supplement. I'd like to answer the question regarding the difference in meaning between apology and regret. I'd like to quote the explanation from the Chinese dictionary. 抱歉 and 道歉 in Chinese all have the same connotation of being sorry. Regret means you feel uncomfortable for what you've caused to that person. Apology means you want to say sorry for what you've done to the other party. Mr. James Toh. Sorry, I had to attend another meeting just now. I'd just like to make one point. The government, in the annex, the government proposed that there is another way to draft the bill, and I support that. I don't know how other members think. Understand? Point taken. Mr. Toh, it's fine. Point taken. Now, regarding Section 8 of the bill, regarding the CSA, we've spent a lot of time discussing this just now. We know that the administration need to go back and having heard our views, they will need to consider this further. In order not to hold up our scrutiny of the bill, we've just started the clause by clause. Anyway, they will come back to us regarding this CSA. They have heard members' views. They will go back and consider this. Okay. Okay, yeah, your point is taken, Mr. Toh. The law draftsmen have explained that there is a slight difference between the two. Is that agreeable to you, Ms. Chow? Okay. We're now up to Section 5. The ordinance applies to an apology made by a person on or after the commencement date of the ordinance. Okay, legal advisor would also like to make a supplement. 3A, admission of fault by inference or by implication. Could the government explain that? Well, in our response, we've already given an example. Whether or not, it depends on what transpired at the time and the circumstances under which the apology was made. We gave an example. Somebody is bow his head. That already implies that that this is really tantamount to an admission of responsibility. Another simple example is to simply say sorry. So when an incident happened and the party said sorry, So the question is that if you say you're sorry, does that mean that you're admitting your responsibility? So, Chairman, the more we read this, you'll find that so means that you are admitting your legal liability. You would be discouraging people who would like to apologize and say they are sorry. Let's see whether the administration would like to respond to that. But I was just thinking that for such admission of fault, now in the apology bill, it's just whether you imply that you have, but the whole bill, the purpose of the bill is to protect you, Chairman. We're now doing the clause by clause. In Section 4, we are dealing with the meaning of apology. But if we go to Section 7, we are explaining the effect of the apology. That if the bill were enacted, then they could not be, it would not be used as evidence to prove in a civil proceeding as to whether or not the person has a liability. That's why 8(2) is so important. Yeah, we understand Dr. Cheung's concern. Yes, if you read carefully, you'll find that in future, when the doctor needs to explain to the family of the patient about the situation of the patient, he may not even want to do that. The doctor will simply say, well, your relative passed away, and he will not say anything else. They will not explain to the family the cause of death. I mean, this is what will happen when this apology bill becomes a law. People will be discouraged from making an apology. Well, I think it's almost time for us to wrap up now. I believe that for the clause by clause, we can stop at clause 4 today, and we can carry on. We haven't yet finished with the scrutiny of clause 4 yet. So for the clause by clause, we will continue with that at our next meeting. But there's one point I'd like to consult with members. Although we've started the clause by clause today, we need to finish it yet. We also need to follow up on clause section 8(2). We have 2 dates scheduled for our next meetings. The 13th of June, that's Tuesday next week, at 4:30, we can hold another meeting. Other than that, let's see whether we can also schedule for another meeting on June the 19th at 8:30 in the morning, a Monday, for us to have another meeting. Mr. Chung, I'll repeat that again. 13th of June, a Tuesday, next week at 4:30, we hold another meeting. We have scheduled one more meeting, which is for on 8:30 at 8:30 on the 19th of June. After we start the scrutiny of the bill, we will still need some time yet to deal with the other aspects, even if they're not controversial.
8(2) 嗰度我哋都
And on clause 8(2), it must be dealt with as well. Dr. Chan, I'm not free on the 13th. the administration's judgment on Clause 8.2 would affect other provisions on whether I have questions on other clauses as well, if you do not tackle Clause 8.2. So today is just the 9th. Can we give the administration a week to think about what to do with it? We still have time. You want to introduce the bill into LegCo by July, but so long as we still have a dispute on Clause 8.2, then we cannot meet the current term. So the Clause 8.2 is very important. If we are to legislate, it must be benevolent. If there is a potential for negative issues, we would rather not legislate at all. Anything to add from the administration? I understand Dr. Chang's concerns. I just want to make sure that I understand you correctly. Do you want to take away statements of facts altogether in the definition of an apology? Do you want no protection on the statements of facts? We hope that the discretion under Clause 8.2 would be taken away, but that statements of facts can be included in an apology. Is that correct? Dr. Chang, in principle, we hope that under Clause 8.2, well, we hope that the entire Clause 8.2 can be taken away. We feel that statements of facts should not be included by the decision maker on discretion. In the apology legislation, contents of an apology should not be admitted as evidence or Thank you. Since time is up for the meeting, I think we can discuss this later or after the meeting. We have talked about the proposed dates for the next meetings. If we have extra meetings, we will work with the Secretariat and administration. That's all for the meeting today. Thank you very much.